Good afternoon, everyone. My name is John Cornwell, and I'm the Director of Practice Development here at Plunkett Cooney. I have the pleasure of coordinating today's webinar, so please let me be the first to welcome you to today's program. Today's webinar will focus on our topic our attorneys are frequently asked about, which is Michigan's Alternative Dispute or ADR system. Alternative Dispute Resolution, I should say, or ADR system. As you will see in a few moments, ADR is a complicated system and that can be it can have a dramatic impact on your liability. But before we get started, I just want to take a few moments to provide you with some background about our firm. I'll introduce our attorneys and we'll get underway. So for those of you who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and most accomplished law firms. We have approximately 120 attorneys in 7 Michigan offices, and we have locations in Chicago, Illinois, Columbus, Ohio, and Indianapolis, Indiana. Our torts and litigation practice group is comprised of attorneys across the region who focus their practices on various aspects of general liability, food service and hospitality, retail liability, premises liability, dram shop law, and other related areas of litigation. And our attorneys routinely defend cases involving retailers, hospitality establishments, religious institutions, commercial property owners, and other businesses that are insured by some of the world's largest insurance providers. So with that, I'm going to introduce you to our speakers today. Joining me for our discussion are 2 members of Plunkett Cooney's Torts and Litigation Practice Group, Bob Marzano and Kelsey Hall from our Bloomfield Hills, Michigan office. I'll start with Bob, and he's a member of our board of directors and serves as co-leader of the firm's Torts and Litigation Practice Group. Bob focuses his practice in the areas of premises liability, food service and hospitality law, real estate law, third-party auto negligence claims, and governmental law. Bob's a member of numerous professional and industry associations, and he's a frequent speaker on his various areas of expertise. Kelsey maintains a busy litigation defense practice with expertise in premises liability, general negligence, and motor vehicle negligence claims. She represents policyholders of some of the nation's largest insurance providers, and she contributes to Plunkett Cooney's Litigation Defender blog, which if you haven't checked it out, I recommend you do. We'll talk a little bit more about that later. And our blog, The Litigation Defenders, covers all aspects of general and retail liability claims, as well as disputes involving construction law, tender of defense, and indemnity claims. Now, before we get started, I want to just cover 2 quick housekeeping notes about today's program. If you are interested in submitting questions, we're going to have a chance to do that toward the end of the program. So now would be a good time to locate in your GoToWebinar dashboard the questions area, and you can type in questions throughout the program, but we'll probably wait until the end to try to answer those. So please go ahead and do that. The other thing I do want to mention is that today's program is being recorded, and that recording will be available on Plunkett Cooney's website, which is located at plunkettcooney.com. So once again, on behalf of our firm, thanks for attending today's webinar. Now let's get things started. Bob, I believe you're kicking off our discussion, so please take it away.
Well, good morning, everyone. The first area we're going to talk about is what is alternative dispute resolution. What ADR is a series of techniques that can be used to avoid the necessity of having your dispute heard by a panel of jurors or by some type of appellate court. ADR is available anywhere up throughout the entire litigation process. It is not unusual to have parties agree to go to a early facilitation prior to a lawsuit being filed. We'll get into a little bit later the pros and cons of that, but that's really the starting point of where ADR can come into play when you have a dispute that you're handling. It is, of course, quite common during litigation, but prior to trial, for the parties to agree to go to some type of ADR. And again, we'll get into this in a bit, but in Michigan, it is required, it is mandatory. And finally, even after your case is over, whether you have an interlocutory appeal or an appeal by right, you've had a jury verdict, or you've won a summary disposition motion, and now you're in the appellate courts, anytime up to the Michigan Supreme Court's final decision on your case, you can go to some type of ADR process if you so choose. In fact, even in the Court of Appeals, the court inquires into whether or not the parties would be willing to get together and facilitate or mediate a case. So it is available throughout the entire process. At this point, I'm going to turn the table over to Kelsey to talk a little bit about why we use ADR.
Good morning, everyone. So ADR has several different advantages. So for instance, many dispute resolution processes are often cheaper and faster than traditional legal processes. And these certain ADR processes can provide parties involved with greater participation in reaching a solution, as well as more control over the outcome of the dispute. Dispute resolution processes are often less formal and have more flexibility than you would see in the trial court with rules and things like that. So first, ADR is an opportunity for parties to essentially, put a matter to bed. It's a final resolution of a dispute. So just like if a court issued a ruling, the dispute would be completely resolved. And depending on the method of ADR that you use, some type of award judgment will be entered or an agreement will be entered between the parties, dismissing the dispute and making it so that these issues can't be re-raised in the future. It also removes the risk of having a judge or a panel of judges issue a ruling on a key issue in the case, including dismissal of the lawsuit. So this is beneficial to both parties in avoiding certain risks. So for example, for plaintiffs, it can eliminate the risk of the judge dismissing the case after defendant files a summary disposition motion, or if the defendant files some other type of motion and the judge makes a ruling on a key issue that could hurt plaintiff's case. It also allows the parties to avoid the risk of going to trial and taking the risk of what a jury could possibly decide. So if the parties settle, plaintiff is almost guaranteed to get something, and defendant doesn't have to pay the cost of going to trial or possibly being on the hook for a larger amount awarded by the jury. So it's a very cost-effective tool. Litigation is expensive. That's just the truth. From the time a lawsuit is filed until a jury or a judge makes a decision, costs are extremely high. I mean, trial can cost upwards of $40,000, even more depending on the claim. And so ADR is just a really effective tool to eliminate this cost. And while parties may still need to engage in discovery before participating in alternative dispute resolution, it is significantly less than the cost of trial. Also, if you can get in a room with the other side before discovery even begins and come to an agreement through the ADR process, I've seen some cases, go to mediation before discovery even begins. That's even better because then you're completely eliminating the cost of some of the litigation. On the topic of discovery, ADR is also just a great discovery tool. It can be really helpful to determine exactly what the other side is claiming and the evidence that they have to support their claims, along with the arguments that they may make. So even if you don't come to a resolution or an agreement during your ADR process, it can still be really great to get a taste of what the other side may argue at trial or the evidence that they have to present to the jury or a judge. So Michigan has several different ADR options, and I'm going to just quickly give a brief overview of each of them, and then we'll break them down further. So case evaluation in Michigan is mandatory. It's a mandatory form of alternative dispute resolution for most civil cases seeking monetary damages. So it often involves a panel of 3 attorneys assessing the monetary value of the case, and this often comes before trial but after discovery, and then the attorneys on the panel will recommend a settlement amount to both parties. If both parties accept the panel's award, then the case is settled, but if not, then it's going to proceed to trial. So both parties will typically submit a brief and supporting documents to the panel, and then the attorneys will then give an oral argument to the panel. So, some people may be familiar with this, but prior to January 1st, 2022, case evaluation had a little bit more of a bite. So basically, if one of the parties rejected the award that the panel gave out, the rejecting party would be at risk in the form of sanctions, and they would have to essentially pay the other side's actual costs, which would include reasonable attorney fees and taxable costs from that point forward. And I'm sure Bob will touch on that a little bit more. But in 2022, the Michigan Supreme Court removed these sanctions for rejecting parties, and now if you reject, there's no sanctions, and the Michigan Supreme Court has also allowed parties to stipulate to alternate forms of dispute resolution with the court's approval. Facilitation is voluntary, but it can also be made mandatory by the court. Sometimes courts will order facilitation if they see a need for it in the case. Facilitation and mediation are terms that are often used interchangeably. In facilitation, a neutral third-party facilitator will help guide discussions and help the parties understand each other's perspectives and then encourage them to find a mutually acceptable solution. So with the changes to the case evaluation rules, we really see a lot of Michigan courts encouraging parties to consider facilitation as a way to resolve these disputes. Facilitation really has proved to be a very useful tool in Michigan in getting parties to settle cases. The final ADR option that we have in Michigan is binding arbitration. And binding arbitration is essentially a process where the parties agree to resolve a dispute through an impartial third party, and the arbitrator's decision is final and legally enforceable. So this means that the parties must accept the arbitrator's ruling and generally cannot appeal it. Binding arbitration is completely voluntary, and the parties will typically discuss with each other whether binding arbitration is a good fit for the case. Both sides must agree to it. And then there's also circumstances where binding arbitration will take place if you agree to it in a contract, and we'll touch on that more a little bit later.
All right, thanks, Kelsey. Before we get into the case evaluation process, I wanted to bring up an interesting point. Kelsey talked about removing a matter before a decision is made, either by a judge or a panel of the Court of Appeals. A recent case that I had, we had a rather interesting issue that was up on appeal, an interlocutory appeal, meaning that the case was stayed until, the case was not stayed, but if the Court of Appeals ruled prior to the trial, it would have had a big effect on the trial, one way or another. It would have been very pro-plaintiff or very pro-defendant, would have changed the outcome of the case. The parties knew that and decided we're going to facilitate this matter with the hope that we can come to a resolution before one of us gets in trouble with the decision. We were able to resolve the case, and we found out the panel of the Court of Appeals judges after and felt that we had made a good decision to resolve that case. So you never know who your panel is going to be on a Court of Appeals case, and sometimes the devil you know is way better than the devil you do not know. So that's just kind of an anecdotal story. Now on to the case evaluation. In Michigan, our mediation process is called case evaluation. Years ago, when I first started practicing, it was called mediation, but now they call it case evaluation. This is mandatory under our court rules. All tort cases must go through case evaluation unless it's removed from case evaluation, which we'll get to in a second. The case evaluation process is cheap. It costs, I believe, $75 in total to go to case evaluation. You pay each case evaluator $25. And I will tell you, in my opinion, you get what you pay for. There's a case evaluation panel. There's 3 attorneys that sit on this panel. There is an attorney that most of his or her practice is in plaintiff law. There's one in same thing for the defense law that is so-called neutral. I probably have per month 10 to 15 cases that go through case evaluation, or at least are scheduled to go through case evaluation. Typically, the attorneys that are sitting on these panels do not practice a lot of law, trial law. The neutrals are typically plaintiff attorneys. They're not defense attorneys by any means. A lot of in-house counsel sits on these panels. City of Detroit lawyers, we are just not getting a panel that's really versed in what your case is about. Now, 1 week prior to the case evaluation hearing, each party submits what's called a case evaluation summary. That is essentially a trial brief. You go through the statement of facts of your case, the liability issues, the damages issues, and oftentimes the plaintiff will request an award. And it's usually some ridiculously high award that has nothing to do with the case. A typical sprain of your neck and they want $500,000. I don't know why that's done, but perhaps they think it's going to influence the case evaluation panel. Next, only the attorneys attend the case evaluation hearing. There are no clients allowed. There's no testimony that's allowed. It is simply the attorneys and the case evaluators. Now, the hope is that the case evaluators have read your brief before the case evaluation hearing begins. When I say hope, I would say there's about a 50% chance that's done. Lately, I've been finding that the case evaluators will say, have you and plaintiff's attorney talked about a possible resolution of the case? And my answer always is no, or we wouldn't be here, or yes, we have not got anywhere. So they typically will throw us into a breakout room, which is very unproductive. The plaintiff attorney will say, hey, let's agree to a number. Our clients won't know the difference. Well, I don't think that's a good practice. If we're going to go through the process, we go through the process. So then we come out of the breakout room, and the panel will say, okay, go ahead and present your case. They'll give you about 5 minutes to present your entire case. A good panel will have some questions for you. Most of the panels just sit there and listen. At the end of the hearing, the plaintiff will be in the Zoom room. These are all done by Zoom for the most part. The plaintiff will be in the Zoom room with the panel. The defense attorney will be excused, and the panel will vary plaintiff's counsel. What's the least amount of money your client would take? Here's the problems you have in your case. You got this problem, that problem. The plaintiff attorney gives a very inflated number because, of course, he or she knows it's going to be discounted. Well, the same process then goes through the defense attorney. We go through the defense attorney, whereby, Bob, your case is not a good case. The jury's never going to believe this. You're in a bad jurisdiction. I mean, you name it, they come up with it. What would your client pay to get out of this case? And at that point, I, of course, typically give a rather low number because I know they're going to inflate it. Depending on the county you're in, awards are issued either the minute the hearing concludes, shortly thereafter the same day, or within a day of the hearing, you'll get an award. The case evaluation award is supposed to represent the settlement value of the case. It is not the settlement value of the case most of the time. It is usually a pretty highly pumped up number that is plaintiff friendly. I don't understand why that has been. It's been this way for the last few years. The theory is that the case evaluators at one point in time were trying to help the plaintiff's bar with keeping cases being filed, which we no longer have a problem with in Michigan. But nevertheless, the award typically is quite pro-plaintiff and quite high. Oftentimes, the issue of liability is completely ignored by the panel. I've actually had panels tell me, we're not here to evaluate liability. That's the judge's job. Well, if you're just evaluating a case solely on damages, you're not getting to the true settlement value of the case. But nevertheless, that's what we're stuck with. Now, each party has 28 days to accept the award or reject the award. If both parties accept the award, the case is settled. But you've got to be careful because under the court rules, if both parties file an acceptance, then the case is settled for that number. The plaintiff is not under an obligation to sign a release, even though the two parties have accepted. The stipulation and order of dismissal will serve as the release, as long as the payment is made of the award within the 28 days following the deadline to accept or reject the award. So, say for instance, May 1st is the deadline to accept or reject the award, and both parties have accepted. As long as the plaintiff's counsel has paid the settlement, the case violation award by May 29th, they have to sign a stipulated order of dismissal with prejudice. There is case law in Michigan that says that will serve as a release. Of course, everybody would like to have a release. We'll get to how to get that in a second. But let's say that payment does not come before May 29th, that you pay 30 days later or you pay 60 days later. The plaintiff can, and it's rare they do this, but the plaintiff can move for an entry of a judgment, which the case violation award will then be converted to a judgment, and post-judgment interest will apply to every day that that judgment's not paid beyond that 28-day period following the acceptance rejection date. So you got to be a little careful there. Now, there's two options you really have with respect to how to handle a case where both parties want to accept the case violation award. One is you can call the other party up and say, listen, if we accept and you accept, will you allow your client to sign a release? 99% of the time, the plaintiff's attorneys say, yes, we will. Then you have no problem accepting as long as they will too. But I would recommend, unless you know that the case is going to be settled, you reject the case violation award, and here's why. There are no sanctions or no penalties for a party rejecting the case violation award. Years ago there were. Now there's not. And that's why this process really has no meaning. It is very rare that any party, plaintiff or defendant, will accept a case violation award. The reason being is the defendants don't want to set a floor, and the plaintiffs don't want to set a ceiling for future settlement negotiations. Typically, the parties will call each other now and say, hey, case violation was $45,000. Would your client pay if my client would take it, or vice versa? And the case settles that way. If you've accepted an award, in the old days, the argument would be, hey, we only accept the award to avoid sanctions. And now that we've got past that, we're not willing to pay that kind of money. Well, that excuse doesn't exist anymore, or that tactic doesn't exist anymore. And when you go to a settlement conference with a judge, you're starting at that case violation award if you accepted it. Same thing with a facilitator. So it is kind of an art now how you handle that. You could always go back to that number, but there is no penalty for rejecting the case violation award. And unless something very strange, I'd recommend it, because otherwise you're setting yourself up for difficulty negotiating the case going forward. Now, how do we get out of this mess? How do we get out of case evaluation? There are a few ways to do it. You could file a motion with the court saying that this case isn't appropriate for any type of ADR, and the court may grant that motion. You can't just ignore the case evaluation requirement, but courts can relieve you from that. That is very rare that's going to happen. Judges don't like to hear that parties don't want to engage in some type of ADR. Depending on the county you're in, different counties handle their pretrial orders and their scheduling orders differently. Wayne, Oakland, and Macomb, you don't have a choice. Counties, you will get a scheduling order with a case evaluation date contained within that scheduling order. Some of the other counties around Michigan will give you the option of, do you want to go through case evaluation? Do you want to go through facilitation? Is there some form of other ADR you can come up with you'd like to go through? They'll let you choose. There are judges that are starting to hold pretrial conferences in the Tri-County area, Wayne, Oakland, and Macomb, where they say, we want you to facilitate the case. We prefer to get you out of case evaluation, and we'll do it. But a majority still, it's just on the scheduling order. Now, typically what happens is the parties will stipulate to remove a matter from case evaluation. And the courts, for the most part, are fine with that. It is imperative that you check with the particular judge's protocol. There is a judge in Wayne County that says you cannot remove a matter to facilitation in lieu of case evaluation unless you do so within, and I can't remember what the date, it's like 150 days from when the complaint was filed. Other judges could care less. But it is very rare a judge won't sign that stipulation. And the stipulated order typically has to have the name of the mediator, or the facilitator, the date, time of the facilitation, and then a blurb about either it's going to allow the facilitator to turn into the sole case evaluator if the case doesn't resolve by way of facilitation, or it's just removed from facilitation or case evaluation altogether. Once that's entered, you're fine. Now, if you don't have a facilitator picked or you don't have a date, courts are not terribly willing to allow case evaluation, you to remove your case from case evaluation. My recommendation is this is done early on in the case, long before that case evaluation hearing approaches. You have a much better chance of having the judge allow you to do so. Scheduling facilitations in Michigan take forever. If I was to schedule a facilitation today with a good facilitator, I'm looking at probably August, if I'm lucky. And where you run into trouble, too, is there are some judges that may require it. And again, we'll get into this in a second, but you're going to get stuck with somebody who's available right now. And I can tell you, those folks are not the facilitators you want. So again, there is a way to get this case out of case evaluation. The key is doing it early and having everything set up and making it easy for the court to do it. Okay, now facilitation. I personally am a huge fan of facilitation. I think it is a great process. When I say it's typically voluntary, it is. However, in Michigan, courts have the power to order facilitation, parties into facilitation. There are some judges who, if you go through the case evaluation process and say you get a $50,000 case evaluation award and nobody accepts it, the next step is you go to a settlement conference with the judge. The judge will then say, have you facilitated the case? No. Okay, would you guys like to facilitate the case? No. Okay, I'm ordering you into facilitation. There are some judges that will not try a case until the parties have gone through a facilitation. So the judges can push you into it. Facilitations aren't cheap. Typically, if you've got a good facilitator and you're going to spend 2 to 3 hours with that facilitator, maybe even 4, each party is going to pay probably between $1,000 to $2,000 for the facilitator's time. However, in my opinion, you get what you pay for. It's money well spent. Now, as far as selecting a facilitator, pretty easy. There's a typical group that most of the people want to use. These are the folks that are very busy. You call the plaintiff's attorney and you say, hey, listen, who do you want to use? Typically, the parties will agree on someone. Occasionally, you'll get some pushback from a plaintiff attorney, or there's sometimes I say, hey, I'm not using that person. They're horrible. I typically tend to let the plaintiff attorney sort of take the lead on this because my clients are sophisticated, either insurance carriers or folks that have enough knowledge of how to resolve and value a case. And I don't need a facilitator to tell us how much our case is worth. It's the plaintiff they need to lean on. So if the plaintiff attorney thinks a certain facilitator is going to get through to his or her client, great. That's the whole goal, is to use that person. But again, you get what you paid for. And if your attorney's recommending facilitation, I always ask, tell me about the facilitator. Who are you going to use? Have you used this person before? How do they operate the facilitation, which we'll get to in a second, but there's a lot that goes into selecting the facilitator. Next, what will happen is once you've selected a facilitator, they all have different things how they like the facilitation to run. Some will want the facilitation summaries, which are identical to a case evaluation summary, a week before the hearing. Some want it the night before the hearing. Some say, I don't care if you even submit one. If you want to submit one, it's your business. I highly recommend you do so. It's good to, A, educate the facilitator as to what's going on, B, educate the other party as to your position, and the evidence that you're using to support your position. And C, during the facilitation, facilitator's going to come to you and say, listen, plaintiff says this, and you say that. What evidence do you have to support your position? Well, you can say, if you go to Exhibit C, line 5 of plaintiff's deposition, here's exactly what plaintiff says. Well, that allows the facilitator to go right to the plaintiff and say, you said this. Here it is, quote unquote. You can't argue against that. So it's worth putting the time and effort into a good facilitation summary. Now, the facilitation hearing can be done in a variety of ways. It can be in person, which is becoming very rare, where all the parties are there, they go into different rooms, and the facilitator goes back and forth. Next, it can be by Zoom, which is more common, where everybody's in the Zoom room. The facilitator will keep pulling the attorneys in, pulling the attorneys out. If you're stuck having to sit through that, it's a long process. You could be doing other stuff and not be on Zoom. And that leads to telephone. Oftentimes, this is how facilitations are done. There are certain facilitators that will only do it by phone. And the way that works is simple. The facilitator will call the plaintiff attorney and say, listen, I'm a facilitator, blah, blah, blah. They'll talk about the case, what the plaintiff's opening demand is. Then they'll call the defense attorney and say, okay, plaintiff's demands this. Bob, tell me about your case. Where do you want to see this case end up? Oh, boy, it's never going to settle for that low. Blah, blah, blah. And I always say, all right, well, what do you recommend I open up with? And we're paying this person for their expertise. And if it's a number that I can live with, that's fine. But I always call my client and say, listen, before I make a move, here's the plaintiff's demand is, here's what I've been told by the facilitator. What do you want me to do? Here's the recommendation. Also, I always offer the opportunity for the client to speak with the facilitator if necessary. Pretty rare that's done. Facilitation to go back and forth to settle negotiations, and you'll either get to a point where you settle the case by both of you accepting a number, or you get to the potential facilitator's proposal. Now that is something the facilitator typically will offer the parties. Most good facilitators will say, listen, I'm not going to tell you my number, but it's going to be between $50,000 and $75,000. I'm not saying you have to agree to accept that, but as attorneys, would you be willing to recommend a number in that range to your client, whatever it may be? The attorneys always say, well, yes or no, I don't think I would, but why don't you put a proposal on it? Let me see what we can do. So you get a proposal. It's usually a day or so later. And the parties can agree how long that proposal is good for. It could be good for a day, it could be good for a week, it could be good for a month. And what will most typically happen is this. You will have a certain day where the response is due, either a yes or a no. And if there are 2 yeses, the case is settled. If there is a no, the party that has submitted the no will never know what the other party did. The yes is always protected in the process, so you don't have to worry about, well, if we accept and they reject, they're going to know. So if you say no, you're never going to know what the other party did. Now, the next step after facilitation, there are times when cases do not settle through facilitation. I would say I probably settle about 80% of my cases through facilitation. But the other 20%, what happens? Well, oftentimes the facilitator will contact you and say, hey, is there anything I can do to keep this, this process going? And I've had, cases where we went through weeks of those conversations, and we eventually got to a resolution. Or if something changes in the case, we contact the facilitator. It's not unusual to facilitate a case 2 or 3 times, especially big cases. You just keep getting closer and closer and closer to a number. But it doesn't mean just because you walk out the door and the case isn't settled, the facilitation's over. Then the biggest reason I like facilitation too is it brings finality to the case. The case is settled. There'll be a payment made, an order of dismissal on it, a release signed, and you close your file. There's not, hey, we won a trial, but now there's going to be 6 years of appeals. Or we won I had a case just recently, I'm not kidding you, I had it dismissed about 6 or 7 years ago by way of a motion. It had gone up to the Court of Appeals and sat and the Court of Appeals disagreed, sent the case back. Now I've got a case I haven't seen in 7 years with a new judge who says, well, what are we going to do? I guess we're going to try the case. I mean, I don't, was the plaintiff changed in 7 years? I mean, has there been more treatment? Typically, plaintiffs don't get better after dismissals. They do get better after settlements. So in any event, it's good you put this one to bed, you close the file, and you don't have to worry about anything like that coming up. So with that being said, I'm going to turn the table over now back to Kelsey. She's going to talk to you about binding arbitration. Kelsey, take it away.
Thanks, Bob. Yeah, so binding arbitration typically is mandated by a contract. There are situations where parties can choose to engage in binding arbitration, but this just isn't as common. So when you sign a contract with a valid binding arbitration clause, it's going to be enforceable, meaning the parties must resolve their dispute through the arbitration instead of the court. The biggest and most common example of this is with commercial contracts. So businesses will often include arbitration clauses in their contracts to provide a streamlined and cost-effective way to resolve disputes. But like I said, you know, parties can choose to enter into a contract to go forward with binding arbitration. So the agreement must be, you know, in a written record. It has to waive the right to sue. It has to specify, you know, the issues that are going to be arbitrated, and it's got to be signed by both parties. And this type of arbitration is going to be mandatory, and the award is going to be final. So typically in Michigan, arbitration or a selection of an arbitrator typically involves either a mutual agreement by the parties or a process that is outlined in the contract or the agreement. So if the parties disagree, they can seek assistance from the American Arbitration Association if they choose to arbitrate through the American Arbitration Association. And if no agreement is reached for who the arbitrator is going to be, then the court can step in and possibly appoint an arbitrator. So here in Michigan, MCL 600.5073 talks about the panel. And so here in Michigan, a panel of arbitrators can either consist of a single arbitrator, or you can have a panel of 3 arbitrators. So arbitration also, there's different types of costs that comes along with arbitration. So you have like administrative fees that you often will pay to the American Arbitration Association. Most people opt to go through the American Arbitration Association, and then you also have fees that are paid to the arbitrator. The arbitrator usually, their compensation usually depends on how much work they have to do on the case. So depending on the rules in the case, the rate might be set by a fee schedule that they have, or it could be, you know, per hour, per day, or per hearing. You also obviously have administrative fees, including filing fees and hearing fees, things like that. Of course, it's going to cost money to prepare your case during the discovery phase. Should the parties choose to engage in discovery prior to, you know, going to an arbitration hearing, it obviously will cost money to prepare your case and then have the hearing. Something interesting about binding arbitration is there's a tool called a high-low agreement, which it's a tool in which parties can set a maximum and minimum recovery value and therefore, you know, eliminate the risks at play in the litigation. So if a plaintiff is awarded a sum in excess of the maximum amount that was agreed upon by the parties, then they recover only that maximum value agreed to in the high-low agreement. If the defendant prevails, then the plaintiff is going to at least recover the minimum value that the parties agreed upon. So this is mutually beneficial to both parties. The plaintiff is guaranteed at least some recovery, and the defendant is going to be protected from the risk of an exorbitant award. So with regard to the award, the arbitration award, when both parties have, presented their case to the arbitrator or the panel, the arbitrator is going to issue an award. This is going to be the arbitrator's final decision on the case. It's akin to a judge or a jury's decision in a court case. After the arbitrator closes the hearings, no more evidence or arguments are going to be allowed. Then the arbitrator is going to write the award, and then it's going to be sent to the parties. Most parties will voluntarily follow the arbitrator's award or decision. However, if one party wins the arbitration and the other party does not do what the award says, they choose to not follow it, the winning party can go to court to confirm the arbitration award. So parties to the American Arbitration Association cases where they choose to do it under that, they can agree, it's agreed to that the arbitration award can be entered as a judgment in any federal or state court with jurisdiction. And this means that the court can then enforce the award like it was any other court judgment. Following, the arbitration award, there is a small area for appeals if there is something that came up that would allow for an appeal. So the American Arbitration Association can only handle an appeal if an arbitration award is agreed to, if the parties agree to an appeal of the arbitration award. So there's no automatic right to appeal like you would see in court. So if the parties agree to use the American Arbitration Association to handle the appeal, then the association is going to treat the appeal like a new case, and you'd have more filing and more fees that would have to be paid. However, if you want to challenge the award in court, under federal and state laws, there are a few different ways to challenge the award. So the Federal Arbitration Act provides limited reasons as to why an award can be vacated, modified, or corrected. In Michigan, a court can vacate an award if it was procured by corruption, fraud, or other due means. And then also if there was evident partiality by the arbitrator, meaning, the arbitrator was showing some signs of not being impartial, or if the arbitrator exceeds their powers. Michigan also allows a court to modify or correct an award if there's evidence of like a miscalculation or a mistake in describing a person or a thing, or if the award is imperfect in form, meaning that there's some minor error, but the underlying decision is correct.
All right, so what ADR process is best for you? Well, it's up to you. It really depends on the case that we're dealing with. And if you've got a case that's worth $15,000, is it necessary to go through facilitation? Probably not. Obviously, high-value cases do, I think, resolve much better by way of a facilitation, sometimes several facilitations. But the question you first have to answer yourself is, do we want to settle the case? If it's a case you want to settle, then the question is, how are we going to do it? And again, and I may seem biased, but I think the case relation process is worthless. It is more harmful than helpful. One of the problems you run into is this. If you go to case evaluation first and say, well, let's see what happens. It's $75, it's cheap. And you've got a case that you want to settle for $50,000 or lower, and the panel comes back with an award of $125,000 in favor of plaintiff, and you say, what the heck happened? And your attorney tells you, I told you these panels are crazy. They don't listen to liability. They don't take into account, pre-existing problems, and they were buddies with the plaintiff attorney. So now you got $125,000. Well, now you've got a problem because the plaintiff attorney's got to say, hey, the facilitator is recommending that you settle this case for $35,000 or even up to your 50, and the plaintiff, who's not a sophisticated person, says, well, hold it. 3 lawyers said my case is worth $125,000, and you're telling me I should take 50? You're crazy. I'm going to fire you, or I'm going to sue you. It's very difficult to explain to a plaintiff that the award is something that has to be ignored. I mean, we've all had those cases where your defense attorney comes to you and says, we got a $10,000 award. It's never going to settle the case. Don't get excited. And most of the time you'll know why. But again, if your goal is to resolve the case, get this thing into facilitation. Obviously, I literally got an email yesterday which shocked me. This is how bad our society's come with facilitations. Everybody uses them. That's why they're so busy. Is it possible to still negotiate with the plaintiff attorney without a facilitator? And I'm like, of course it is. The old-fashioned way of negotiation still exists. We're still allowed to do it. But these are just processes that have it's almost become part of the trial process. So with that being said, we'll turn it over to any questions anyone may have.
Okay, great. As a quick reminder, we're going to ask everybody that might like to ask a question to go ahead and use the questions window on your GoToWebinar dashboard. It's in the top right corner. It's got a little question mark in it. I'm going to just take a minute and see if any are coming in. While we're waiting, I do see that we do have one question in the queue, so I'm going to go ahead and throw this out for Kelsey and Bob. It says, it seems like case evaluation is a lot cheaper than facilitation, so is facilitation worth the money?
Well, as I've said, yes, I think it is. You get what you pay for most of the time in life. In this case, you certainly do. You're going to probably pay for a facilitator one way or another. In most cases, with most judges are going to require it. And if you have a case evaluation award sitting out there that is unfavorable to you, which they typically are, it is going to make the process of resolving the case that much harder. So, as we just discussed.
Great, thank you very much. Again, just use that questions window on your GoToWebinar display if you'd like to ask one. I do see one, actually 2 other questions. The next question is, under what circumstances would binding arbitration be a good idea?
Well, I'm not, again, a huge fan of the binding arbitration process because, as Kelsey put it, you, for the most part, lose your ability to appeal anything. If you have a case where there is no question, it's 100% liability. There's no question about it. It's almost a case for you to admit liability. And you're concerned about a potential runaway verdict. Binding arbitration sometimes will be a good idea under those circumstances because you're not going to really have any appeal as far as liability is concerned. As long as there's no crazy evidentiary issues that may end up in the Court of Appeals, and you just got a straight case to put in, and you want to limit your risk or define your risk by a high-low, those are the kind of cases that make sense to go to binding arbitration. By doing that, again, you are saying the most I'm going to have to pay in this case is this. I might have to pay more than it's worth, but I'm not going to pay some crazy verdict. We all know right now that nuclear verdicts are occurring right and left. We've had soft tissue cases in Michigan that have come back at $5 million. I mean, the juries have no concept of money anymore. So again, this limits that risk. But if you've got a case where you've got a liability argument, just get the wrong judge to grant a motion for summary disposition or directed verdict, I wouldn't recommend binding arbitration because then you're giving up your chance to appeal.
Okay, I see one more question. And again, if you'd like to ask one, please enter it now. This is the last question I see. And it says, I thought there were sanctions with respect to case evaluation in Michigan. Has that changed?
Yes, as I said earlier, the old case evaluation process, the way it worked was this. You had 28 days to accept or reject a case evaluation award. If you rejected and you did not improve your position by more than 10% at the time of trial, you would pay the other side's attorney fees from 28 days after the case evaluation hearing up to and through the conclusion of trial. And that could get expensive, especially if there were appeals involved, or it's one of these cases that, you know, go on for years and years and years, and you incur a lot of fees and costs. About, I would say it was about 3 years ago, maybe 4, the rule was amended. There are no longer any sanctions or any costs for rejecting a case evaluation award. At that point, that's where this process essentially became worthless.
Okay, great. I do not see any other questions, so I think what we'll do at this point is wrap things up. At this point, I just want to mention that following today's presentation, you're going to have a survey pop up on your screen. I hope you will take just a couple of minutes to complete that. The feedback you provide is invaluable to us, especially any topics you would like to have us address in the future. So we really encourage you to complete that survey. I do want to give a plug to our Litigation Defenders blog. If you're interested in learning more about general liability matters and the related topics like ADR, this is the place to go. It's on our firm website, plunkettcooney.com. You navigate over to Insights, and then you can find our blogs there. And the Torts and Litigation Practice Group manages the Litigation Defenders blog. So I encourage you to check that out. The other thing I want to mention is that today's session was recorded, so if you missed anything, no worries. Or if you'd like to recommend it to another colleague, please do. The recording hopefully will be posted a little later today on the event page on our website. So just go to plunkettcooney.com for that, and you should be able to navigate to it and get that recording. So with that, I'm going to thank everybody for attending, and thank Bob and Kelsey for a great job on presenting today's topic. And we will bid you farewell and hope to see you at our next program. Thanks so much for attending.